and hand over to you, Margherita.
Thank you very much, Dina, and welcome everyone. Thanks for joining this session, and I'm very happy to be here. As Dina said, the lecture today is on marine conservation law and climate change. And just so you know, I'm working from the UK. I work at the University of Bristol. Just a short introduction from me, and I work on environmental law, but I do a lot of socio-legal type of work. So I use law together with others, environmental social sciences, to explain primarily conservation issues, terrestrial and marine. And today we're doing marine. I would like to just do the standard lecture first, and then we can open up for questions and discussions. Simply because I'm not great technologically, so if I start having chats and things while I'm speaking, it gets difficult for me to see them because of the screens. So please post all your questions in the chat, and after we can have the discussion. We got together an hour and a half. I don't think we need the full hour and a half, but if there is good discussions, of course, we will use it, all of it. So what I plan to do in this lecture is, after a very short overview on the twin crises of climate change and biodiversity loss, discuss the role of marine protected areas as important nature-based solutions. And then I will focus on a case study, which is England, because most of my work is in England, or anyway in the UK. So I will use England as the case study to discuss the very recent establishment of strict marine protected areas known as HPMAs, which stands for highly protected marine areas. And in tracing the history, legal and policy history of these highly protected marine areas, I plan to highlight some of the key challenges. And I will then zoom out, if you like, of this case study, reflecting more theoretically on why we are having these challenges. So making sense of highly protected marine areas or strict marine reserves in general. And to do so, I will use the analytical categories of commons and commoning, which hopefully they can be translated to other contexts outside the domestic English one, a context that you may be familiar with at national or supranational levels. Okay, so to start off with the twin crises, I mean, we all know that climate change is projected to result in increasing societal and environmental risks over the next decades. At the same time, biodiversity is declining at unprecedented rates. And a cause, not the only one, but a cause of this decline is indeed climate change. So I put here a picture in the slides of coral bleaching. So when water becomes too warm, coral expel the algae living in their tissues, causing the coral to turn completely white. And of course, that affects the life of the coral, as well as of those that rely on the coral to survive. So we have, of course, then a negative relationship between climate change and biodiversity loss. At the same time, though, biodiversity can hold the key to mitigate and to adapt to climate change through effective conservation and restoration of ecosystems. And this is why we speak and we hear more and more about nature-based solutions. The IUCN defines nature-based solutions as actions to protect, sustainably manage, and restore natural and modified ecosystems that address societal challenges effectively and adaptively, simultaneously benefiting people and nature. So in my context, how can MPAs be seen as a nature-based solution? They are very much regarded as one because they are vital management tools to lessen the risks of climate change hazards and other anthropogenic pressures to marine ecosystems by aiming to ensure conservation, restoration, and the sustainable exploitation of the resources in our oceans. Now, of course, MPAs by themselves cannot reduce the global impacts resulting from climate change, but they can definitely promote the genetic diversity, they can increase population size and ecosystem integrity, which are very, very important for increasing the resilience to climate stressors. And they can also support mitigation in protecting, for example, habitats for the storage of carbon. This is recognized globally, for example, in the Montreal Global Biodiversity Framework, which was recently, last year, agreed at COP15 of the CBD, of the Convention on Biological Diversity, which has the well-known 30 by 30 target and also pushes for nature-based solutions. So target 3, just a reminder, it reads, ensure and enable that by 2030, at least 30% of terrestrial and inland water areas and of marine and coastal areas, especially areas of particular importance for biodiversity and ecosystem functions and services, are effectively conserved and managed through protected areas. And target 8 explicitly speaks of nature-based solution by reading, minimize the impact of climate change and ocean acidification on biodiversity and increase its resilience through mitigation, adaptation, and disaster risk reduction actions, including through nature-based solutions, etc. Okay, so this is clearly recognized at the global level. And in this respect, strict marine reserves especially hold a very important value as nature-based solution because they can provide an ideal laboratory to test the resilience of marine ecosystems, as basically most human activities are prohibited. If strict reserves are established in places where the baseline states can be defined, they can act as scientific benchmarks to study adaptation responses of ecosystems, given that the vulnerability from anthropogenic pressures is completely removed. However, from a more kind of social perspective, strict reserves are not very, very easy to bring in place and to be established because they are not a neutral conservation tool. They are very much highly contested and politicized socio-ecological systems. By limiting sea users' access to resources, they can be perceived indeed as the quintessential example of fortress conservation, creating distributive injustices, hindering human rights in this sense. So fortress conservation is a model of conservation based on stringent protectionist logic, positing that human activities in protected areas should be prohibited for achieving conservation aims. And as I said, this raises human rights issues as it bans people from accessing and using resources. And it also is underpinned, if you like, by an ontological dichotomy that starkly separates nature from society. However, as already mentioned, strict reserves do hold a key value as nature-based solutions. So it's really essential that we ensure that these strict reserves are seen legitimate regulatory interventions in the eyes of sea users and the wider public, and they are not perceived as fortress conservation. And this really helps in overcoming social and political resistance against them. And in my view, law and policy can play a central role in enhancing strict reserves' legitimacy as well as effectiveness, especially by focusing and by emphasizing certain procedural avenues and certain institutional practices that enable wider participation. Indeed, I think a lot of the debate on forest conservation is primarily concerned with issues of distribution, okay? So distributive injustice, distributive environmental injustice. But if we bring it in the procedural elements and we think about also procedural environmental rights, we might overcome, if you like, some of the challenges. And by focusing on England, I do review the extent to which these new highly protected marine areas can be more than forest conservation or not. So let's go into then the case study. Now, I don't want to bore you too much with a lot of legal details of domestic English law. All I'm going to say, however, I need to provide you a little bit of a background there. So what I'd like to state is that legally, there is no obligation to have strict marine reserves in England. The key pieces of legislation when it comes to the establishment and management of marine protected areas in England are two. And the one that has been used for highly protected marine areas, strict reserves, is the one that I circled, if you like, in blue, the Marine and Coastal Access Act 2009, which then will be the focus of this presentation. It is a piece of primary legislation. The other piece of legislation that serves for the establishment and management of marine protected areas is a statutory instrument, the Conservation of Habitats and Species Regulations 2017, that then has been amended in 2019 to make sure it remained operational post-Brexit, and that is transposing EU nature conservation law. So it's transposing the Habitats and Birds directives that may be familiar with those of you that are working on protected areas at the EU level. It's transposing those directives into domestic law, and it remains alive post-Brexit, as I said, through certain amendments. But the chosen instrument to create highly protected marine areas in this country is the Marine and Coastal Access Act 2009. So they will be created, and they are created, using then those powers to designate by order marine protected areas that are known in the Marine and Coastal Access Act as marine conservation zones. And they can be designated for the purpose of conserving marine flora or fauna, marine habitats or types of marine habitats, as well as features of geological or geomorphological interest. So the order of designation for these marine conservation zones must state the protected feature or features and the conservation objectives for the marine conservation zones. This is under section, if you're interested in the details, 117 subsection 2. But nothing is said about the level of protection that these marine conservation zones should have, okay? So it doesn't say whether they should be strict or not. That's why I say that there is no legal requirement, but this is the power to establish MCZ, the marine conservation zones, has been used to establish highly protected marine areas. In terms of management, indeed, the only duty on the public authority is to avoid hindering the achievement of the conservation objectives. And therefore, public authorities should not grant authorization for acts that carry a significant risk of hindering those conservation objectives. But there are certain exceptions. So those exceptions that are contained under section 126, subsection 7, tells us that if there are no other means of proceeding with the act, if the benefit of the public of proceeding with the act clearly outweighs the risk of damage to the environment, and the person seeking the authorization will undertake or make arrangement for undertaking measures of equivalent environmental benefits, then public authority can authorize those damaging activities on marine conservation zones. And this exception, which works for the majority of marine conservation zones, can be actually quite problematic when it comes to strict reserves, because if it is applied, it undermines the aim of the strict reserves, because you would allow activities to go on into these areas, and these areas are no longer then strict reserves as such. So this is just a little bit of the legal background. If I go into then a short history of this designation, this is not, for those who have followed English marine conservation law for a while, it is not something very new. It's actually something that is long overdue, because discussions regarding the establishment of strict reserves began over a decade ago during the initial phase of designating marine conservation zones between 2009 and 2011. Back then, the strict reserves were known as reference areas and were meant to offer maximum level of protection and act as scientific benchmarks for the future management of the MPA network that was going to be created. We had a scientific document known as the Ecological Network Guidance that had been developed by statutory nature conservation bodies to provide a scientific basis for the establishment of these marine conservation zones. And this document defined the reference areas, the strict reserves, as areas where all extraction, deposition, or human-derived disturbances is removed or prevented. The way in which they went about recommending marine conservation zones as well as reference areas as part of those was to set up 4 very bottom-up and participatory regional stakeholder working groups around the 4 regions in England that brought together really a lot of interest that were then recommended marine conservation zones. 65 reference areas were recommended by the regional stakeholder working groups as part of these wider proposals of marine conservation zones. However, no reference areas ended up actually being designated. And I think this is quite interesting to look at the history here, because one asks why none of those recommended ones ended up being designated there. So what happened there is that an independent scientific expert group that had been created to provide scientific impartial advice and assessment of the recommended marine conservation zones stated that the recommended reference areas were ecologically inadequate. More specifically, this independent group stated that the recommended reference areas did not meet the ecological criteria for designation that had been laid out in the scientific document I mentioned earlier, this Ecological Network Guidance. Okay? So according to this independent group, the problem had been that socioeconomic interests had been voiced by the stakeholders in the working group, and they have skewed the selection process of reference areas so that the best ecological site had not been selected. I think this is interesting on the basis that it shows that despite initial efforts made toward participatory decision-making, in the end, expert advice and scientific knowledge only were prioritized by the government over other types of marine opinions and knowledges. So the words of this independent expert group and the scientific knowledge at the basis, if you like, of the network guidance trumped the recommendation made collectively by the regional stakeholder groups regarding the establishment of reference areas. And what this briefing window into the history of reference areas shows is that we have a complex picture generally when we're introducing this type of marine protected areas. And in this case, a balance between different knowledges and governance approaches was not found, despite this initial effort at participatory decision-making. We then move on. We move on and we have a gap, complete gap of many, many years in which there's no longer any effort from the government to set up strict marine reserves. Government is busy setting up marine conservation zones, the standard ones, but nothing is said anymore on the strict marine reserves. And this was not really welcome by the scientific community, was not very welcome also by the Environmental Audit Committee, and everybody was pushing for the government to rethink, if you like, strict marine reserves, given their role and their importance. So we end up getting to the 1920 with what is known as the Bennion Review. The Bennion Review is known as such because it was led by a former fisheries ministry called Richard Bennion. The government commissioned this Bennion Review into highly protected marine areas, into strict marine reserves. And they said that the Bennion Review said, yes, we need to bring them in. Strict reserves should be defined as areas of the sea that allow the protection and recovery of marine ecosystems. They should prohibit extractive, destructive, and depositional uses and allow only non-damaging levels of other activities. MPA should be introduced to enable greater protection or recovery of marine ecosystems, and the way in which they should be introduced is to have the ecological criteria first as a primary filter, and then the socioeconomic consideration as a secondary filter. And this was due to the fact that previous approaches that had brought together the socioeconomic and ecological had resulted, of course, in failures of establishing what they were known as reference areas. It was also recommended that an holistic approach is needed. So rather than feature-based designation, we need the whole sites designation. So this review then meant that the government, following the review, decided to come in with a pilot to establish highly protected marine areas. The legal basis for the establishment of these highly protected marine areas, as I already mentioned, is the Marine and Coastal Access Act 2009, because they are designated as marine conservation zones under this act. But we have two key issues. If you remember from the initial introduction I gave into the legal base of marine conservation zones designation is feature-based. The conservation order needs to talk about the features. However, for highly protected marine areas, for strict reserves, we're talking about whole site. So how do we go about using the powers of the existing act to create whole site protection? Well, they've done it quite reasonably by considering the whole site as a feature. So to provide you an example, one of the areas that has been designated in this pilot is Allonby Bay, and the order for designation states that the protected feature of Allonby Bay, highly protected marine area, is the marine ecosystem of the area. Okay, so the whole ecosystem is considered the feature. But there is another issue that is not really resolved and yet, which has to do with the management. Because as you may remember, I mentioned that although the public authorities have a duty to avoid damaging activity in marine conservation zones, there can be exceptions. If, for example, we have the public interest that outweighs the conservation interest. So if those cases happen within highly protected marine areas, it may be that they no longer will be strict reserves. They will no longer prohibit extractive, destructive, and depositional uses. Okay, so it will depend how this section 126 is, and the exception within it will be used by the public authorities. Okay. Now, if we look at then the way in which they have designated, they've chosen these highly protected marine areas, they did really follow the recommendation of the Bennion Review. So we had ecology first and socioeconomic after. In terms of ecology first, they had identified pilot highly protected marine areas using quite specific ecological criteria that had been developed, again, scientifically by the statutory nature conservation bodies, which are scientific advisors to the government, in conjunction with a government agency that specializes in marine and freshwater science called CIFAS, Center for Environment, Fisheries and Aquaculture Science. So they elaborated further these principles in a guidance, a scientific guidance, and they stated that best available evidence using a range, again, of scientific only data set should be used to select these highly protected marine areas. The good news, if you like, was that third parties' proposals were allowed to identify the sites, were invited. So there was a little bit of an effort toward participatory decision making, but these third-party proposals needed to be based on the very specific and technical ecological criteria that had been developed, which means that the openness of this participatory process is actually a bit questionable, given the highly technical language of the ecological criteria, which is probably not accessible to many members of the public or users. Definitely, I, as a non-biology, would find it very difficult to come up with a proposal, a third-party proposal for the establishment of a highly protected marine areas. So following this scientific-led and technical approach, 30 sites were selected. And of these 30 sites, then, to decide which one were going to go ahead, they applied socioeconomic criteria. So that's where the socioeconomic principles and criteria come in. Now, if the ecological criteria and the assessment had been very clearly explained in the scientific guidance note, the same does not hold true for the socioeconomic factors at all. The three principles that they used for considering the socioeconomic factors were the impacts of highly protected marine areas on socioeconomic activities, public and stakeholder acceptability, and effective governance and management, which, they make a lot of sense. However, they were not really subject to any further elaboration in contrast with the ecological principles. Moreover, the socioeconomic principles were primarily concerned with effectiveness rather than, if you like, issues of legitimacy, rather than issues of fairness, accountability, and transparency. So in my view, the view of legitimacy, if you like, advanced by the highly protected marine areas, if we want to talk about legitimacy in the first place, is more one of pragmatic legitimacy, social buy-in, social acceptability linked to effectiveness rather than normative legitimacy, the extent to which the selection process was in accord with fairness, transparency, and accountability principles, with procedural environmental rights for their own right, not because they were useful for achieving a particular conservation aim. Moreover, not all of these socioeconomic principles were actually taken into account during the shortlisting, during the site selection process, during the shortlisting phase, because the main focus was only on the first principle, that is the impact of the strict marine reserves on socio and economic activities. So the effective governance and management and public and stakeholder acceptability were principles that were left to post, if you like, initial site selection. They were left to consultation stage and post-consultation stage. So this is quite late into the decision-making process. And it's problematic because it did not only reduce the information that is available to guide the selection of these highly protected marine areas, so it's not only, if you like, problematic from an effectiveness perspective, but it also undermines the right to for early and participation, for early and effective engagement. Besides, I think the first principle was also very much narrowly interpreted, as its application consisted mainly in understanding the level of economic risk for recreational fisheries and commercial fisheries, removing then the sites that where economic risk was considered very high or critical. So this is quite narrow, and I think arguably the focus on fishing activities is justified by the fact that, of course, fisheries is a major activity impacted by marine protected areas, and also by the fact that the sites selected were places where other activities were not taking place anyway. So there was no renewable, there was no oil and gas ports and harbors or anything like that. They had been excluded for the pilot. However, the factor that these other criteria, these other principles were not taken into considerations leaves one wondering whether the focus was very narrow. Also because the public and stakeholder acceptability, for example, was going to be assessed on the basis of this fisheries information only. But one wonder whether, for example, public acceptability may concern other non-activity related issues. For example, cultural values such as place attachment. Those ones were completely removed from this kind of socioeconomic assessment. So I would argue that quite a narrow view of socioeconomic issues was employed, and their consideration was left very, very late into the decision-making process, which is not ideal. Now, where are we at then after this process? They ended up suggesting putting forward for consultation only 5 highly protected marine areas, some inshore, so between 0 and 12 nautical miles, some offshore between 12 and 200. Of these 5 sites, which are already very few, only 3 managed to get designated in July 2023. So very, very long process, very, very big exercise, and then we end up with 3 sites, only three little pilots. So how do we make sense of what happens? How do we get to here? In order to make sense of it, as I said, I want to zoom out now from the English example and provide certain theoretical reflections that may help us understand better this type of situations. So to do so, I employ the language of the commons and commoning. And I'll explain what I mean by this. So starting out with commons, scholarship and commons in general, I think we can, the scholarship is very vast and very varied. And maybe I'm making some simplifications here, but within common scholarship, we have a lot of emphasis initially on what are known as traditional common pool resources, which is things like fisheries or pastures. So these are actually physical resources that are characterized by high subtractability and the difficulty to exclude users. These are the resources that some of you may know that had been studied by Ostrom and colleagues in their rejection of the tragedy of the commons, of Harding tragedy of the commons. So a lot of common scholarship was generated there and was concerned with these physical, small-scale resources, highly subtractable, and where it was difficult to exclude users. But more and more people looked at also at new commons, what are known as new commons. And the new commons were actually, if you like, the category was discussed in a paper by S, which was part of the Ostrom School, by the way, in 2008, that said that new commons are new types of shared resources, and it could be knowledge, could be biodiversity, and many others, that at the basis of them, there is a commitment more towards future generations to communities beyond the local spheres, and to the common good, the global, if you like, common good. So we're moving from a very local scale to a global scale with new commons, and biodiversity itself can be understood as a new commons. However, the focus remains very much of understanding commons as resources. Now, not everybody is happy with this type of approach, because then all that then people do within this type of scholarship is to try to think about effective governance mechanisms to regulate sustainably the traditional common pool resources, all the new commons. Not everybody is happy, because there's also another strand of, if you like, common scholarship, better known as a kind of commoning, that is trying to argue that commons should not only be seen as things already existing out there, as resources, but as something that is produced and reproduced consciously and collectively by commoning communities. I've put here a quote, and you can read it yourself, which points to this issue. I'll give you a moment to read this quote from the Magna Carta Manifesto of Linnebaugh in 2008. As you can see here, the accent is on doing in common rather than on the resource. It's on the verb rather than on the noun. The focus then becomes on the democratic practices of making the commons, promoting inclusive decision-making. The focus is on the communities themselves, on the commoning communities, which doesn't have to be necessarily only humans, could also include the more than human. And the focus is on that rather than on the sustainability of a thing through shared resource management. So common scholarship, I think, promote a view of institutions as sites where new social and potentially socio-ecological relations are forged, where a common sense of identity is produced and reproduced. Commoning then is a dynamic concept about the making and remaking of participatory common governance arrangements and intersubjective agreement. In this sense, marine protected areas can be seen as institutional sites that facilitate or hindering strategies aimed at social cooperation and collective decision-making for the production and reproduction of shared values, responsibilities, and actions. They should not necessarily only be seen as tool for new commons, for the conservation, if you like, of biodiversity. Because if MPAs are understood as institutional sites, they can really be seen as sites that contributed to the commoning of decision-making by encouraging, for instance, participation practices. So the attention with commoning, if you like, moves towards more procedural issues, which I've argued from the very beginning of this lecture, there should be really a focal point of interest, even in debates and discussions about fortress conservation. So what can I say in this sense then? If we apply those commons and commoning lenses to my case study, but they can be applied to others, I would say, well, in my view, part of the problem that we ended up with only so few sites, and after such, a long time of having to introduce these strict reserves, is due to the fact that highly protected marine areas have been simply and solely framed as new commons, have been framed as resources for the conservation of the common heritage, or the common concern, as the conventional biological diversity will want it, of humankind. Have been framed as places for ecologically important places for current and future generations. So the commoning aspects has been, if you like, downplayed, especially in this latest exercise in which we had socioeconomic principles considered very, very late, and a lot of issues only related to effectiveness and acceptability of fisheries management, rather related to other normative principles of participation or values, cultural values related to marine protected areas. So the government pilot has focused more on the new commons aspect, portraying a narrow view of socioeconomic criteria and leaving much of the discussion to late stage of decision making, thereby not fostering, in my view, at all common practices. HPMAs are just tools that have been framed as tools to protect biodiversity and enable the full recovery of marine ecosystems, thus as new commons. It is not surprising then, I think, that only 3 ended up being designated, and not even the 5, because 2 of them didn't pass the public consultation. The public consultation, if you look at the responses, they lamented the lack of proper stakeholder engagement. They lamented the poor recognition of socio and economic implication of HPMA's designation. And it is quite telling, sorry if I go into the specific, but it's quite telling that to one of the consultation questions that was posed, that is, what effects do you believe highly protected marine areas will have on the following uses and values of the marine environment, respondents emphasize the potential negative effects of designation on culture and heritage and on tourism and recreation. They weren't necessarily concerned with fisheries management. So culture and tourism, of course, alongside commercial fisheries, were important reasons for opposing the designation of an inshore highly protected marine area that in fact didn't end up being designated. So the results from the public consultation do demonstrate the importance the public and sea user attach to cultural values, as well as to early and effective participation, to the right to be involved in decision-making. Of course, this is not to deny that highly protected marine areas' impact on economy, on sea user economy, is also an important factor and has been an important factor for opposing certain site designation. In fact, the decision not to go ahead with another highly protected marine areas was due to the relatively high cost to fishermen. However, the answers from the public consultation, I think, demonstrate that these are, for people, it's more than just economic impacts on fisheries that count when providing opinions on the legitimacy of regulatory intervention. And I'll conclude then to say something like this, very basic, that highly protected marine areas, like whole, I think, marine protected areas, and we shouldn't just, confine ourselves with the marine environment, because these issues are very much encountered also in the terrestrial environment, are not just spatial tools, but are also place-making tool. Okay, they're not just area-based designation for the conservation of nature. And we need to ensure that designations does not create environmental injustices to avoid the perception of waters conservation, but environmental injustices should not only be looked at from a distributive perspective, but also a procedural perspective. Therefore, I think more attention should be put on creating institutional practices that enabling commoning decision-making to have better inclusion of procedural, if you like, environmental rights. And with this, I stop the lecture, and I welcome very much your thoughts, your questions, discussions. If you have your own case studies that you want to discuss, I'm very happy to listen to those. Thank you very much.